I'm Ben Meiselas from the MeidasTouch Network, and this is a breaking news alert. The Ninth Circuit Court of Appeals has set a briefing schedule in the appeal brought by Arizona voters challenging conduct by right-wing extremist groups who have been waiting at ballot boxes, threatening, intimidating, and harassing these voters. We've previously reported here on the MeidasTouch Network how in the lawsuit brought by these Arizona voters, the Arizona Alliance for Retired Americans and Voto Latino, the Arizona District Court Judge Michael Liberty, who is a Trump appointee, ruled that under the First Amendment, these right-wing extremist groups would be permitted to stand by these ballot boxes and intimidate and harass and threaten these voter groups. An appeal was filed, and the Ninth Circuit Court of Appeals has set a briefing schedule. I'm going to read that briefing schedule for you right now. It was done on an expedited basis. And then I also want to talk about another case that is also in Arizona District Court, also before the same judge, Michael Liberty. And the Department of Justice has just intervened and filed a brief there. And I will tell you about the brief that the Department of Justice filed, explaining how the facts alleged in the groups, by these groups, constitutes classic examples of voter threats, intimidation, and harassment that is unlawful under federal law. So now going back to the Ninth Circuit Court of Appeals, here is the order. The order in the case of Arizona Alliance for Retired Americans and Voto Latino plaintiffs appellants versus Clean Elections USA is what this group, this right-wing group, calls themselves. There's also one called Lions of Liberty that works with Clean Elections, which I believe is an outgrowth of Oath Keepers. And this is what the order says. The court has received appellant's emergency motion for an injunction pending appeal. Appellee's response to the motion is due Monday, October 31st. So that Clean Election right-wing extremist group, they got to respond on Monday, and then any reply is due Tuesday, November 1, 2022, signed by the clerk of the court. And so what this tells us, the Ninth Circuit is taking this very seriously. They are moving this forward on an expedited basis. We will have full briefing done by Tuesday, November 1st, and as early as November 1st, we could potentially see a ruling by the Ninth Circuit Court of Appeals panel. And the district court said, Judge Liberty claimed that he could not fashion a injunction that he claimed would not violate the First Amendment rights of these extremist groups, which, if you watch the other MeidasTouch Network video that I did on that, explained was utterly absurd. It would be very easy to fashion an injunction that tells these groups to stop harassing, intimidating, threatening, stalking at these ballot boxes, lurking at these ballot boxes. These groups are yelling at people and calling them mules. They're open carrying weapons by these ballot boxes. They've said that they will be doxing individuals in Arizona who go to these ballot boxes and putting their pictures and photos and information in the public. And these groups also said that they're starting in Arizona and want to bring this conduct to other states. And these groups are led by some of the most wild right-wing extremist conspiracy theorists that there are. And so, yeah, the district court judge claimed, I couldn't fashion an injunction here. We have to allow this conduct to continue, which is just utterly absurd. And then in this other case that went before the same judge that's brought by a different group, this one's brought by the League of Women Voters of Arizona versus Lions of Liberty, LLC et al. Lions of Liberty is one of the right-wing extremist groups, in addition to the Clean Elections, that have engaged in this threatening and harassing and intimidating conduct directed at these voters who are going to the ballot boxes. The Department of Justice in that case intervened and filed a statement of interest. And this is what they say in their statement of interest. They say, this case alleges that organized and sometimes armed groups of individuals have engaged in a campaign to surveil, video record, and harass voters as they exercise their most fundamental right, the right to vote. These allegations raise serious concerns of voter intimidation, which is prescribed under Section 11B of the Voting Rights Act. The United States files this statement of interest for the limited purpose of aiding the court's interpretation of Section 11B and to provide illustrative, but by no means exhaustive, examples of Section 11B's appropriate application to protect voters from threats, intimidation, and coercion. Then it goes on to say, Section 11B broadly prohibits, of the Voting Rights Act, broadly prohibits threats and acts of intimidation and coercion at all stages of the voting process, including voters depositing of ballots in a drop box where provided for by state or local law. By the statute's plain terms, Congress brought within 11B's wide ambit both violent and nonviolent conduct that has the prohibited effect of intimidating, threatening, coercing voters, or attempting to do so. Polling place conduct, such as private surveillance or investigation, that would ordinarily tend to intimidate voters and has little salutary purpose, has long been considered to implicate Section 11B of the Voting Rights Act. And while balancing any prohibition on conduct or potential remedy against an individual's First Amendment rights can present a fact-intensive inquiry, protecting voters' rights to cast their ballot without the specter of threats, intimidation, or coercion is fully consistent with appropriately crafted limitations on private actors' conduct. And so what the Department of Justice is saying here is that the Voting Rights Act has always been clear that conduct like this is illegal. And where you have threats, coercion, and intimidation, the line of First Amendment free speech, which is very important, is crossed into a land of criminality when you start threatening voters. And voters have a constitutionally protected right to be able to cast their ballot peacefully, devoid of threats, devoid of intimidation, without having to be surveilled. And it would be easy for you, Judge, to craft a remedy, to craft an injunction that says this conduct is unlawful. You have a First Amendment right, but you can't wield the First Amendment and weaponize it to threaten, coerce, and then engage in criminal conduct, infringing on the constitutional right to vote. There is a balancing that needs to take place, and the law has long held that this is a fairly easy question to resolve. The Department of Justice is filing this request to intervene, or the statement of interest, rather, in the district court proceeding in Arizona, knowing full well that Judge Liberty has already ruled against voting groups seeking similar relief. So what's the Department of Justice doing here? Well, on the one hand, the Department of Justice is saying, well, this judge obviously doesn't know the law, so we're going to intervene and educate him. But I think that the Department of Justice is doing something else here as well. I think the Department of Justice knows or feels comfortable that the Ninth Circuit Court of Appeals, by November 1 or shortly thereafter, is going to find that the conduct at issue, the threats, coercion, and intimidation, is not protected speech under the First Amendment, and will send it back to the district court judge to change the order and to allow for there to be an injunction to stop these groups from doing it. And so what I think the Department of Justice is trying to do now, they realize this judge has ruled against groups representing voters bringing a similar case against the threats and harassment, and the groups representing the voters have lost. But what the Department of Justice is saying, well, when we think the Ninth Circuit is going to then remand the case back to the district court to reverse its ruling and to fashion a remedy, we want to show you, district court judge, because, look, you were appointed in 2019. You're a Trump appointee, so we know what that means. You probably don't even know what you're doing, and you're just trying to, you're almost like a Judge Eileen Cannon here. I'm not going to insult the judge like that yet, but almost like a Judge Eileen Cannon, like you don't know the law. So let us explain to you what 11B of the Voting Rights Act does and says in a clear and concise way. So ultimately, when you have to fashion the preliminary injunction, which we think you're going to have to do after you get the order from the Ninth Circuit, you will be able to fashion it appropriately. Now, all of this is happening very quickly. Obviously, we are days away from the election. And so everyone is going to be moving very, very, very quickly here. And I want to give a special shout out to Protect Democracy and Democracy Docket and Mark Elias and his whole team for bringing these cases, because bringing these cases and suing these groups and letting these groups know that there is repercussions for their threats, intimidation, and harassment in and of itself is effective. And we are lucky for the work of Protect Democracy, the work of Democracy Docket, the work of Mark Elias in particular, and frankly, his whole team, because I know there's a number of lawyers at that team, and we all know the great work that Mark does, and I'm sure he was on the podcast too, but I'm sure he'd be the first to tell you too that the work that he does is not possible without the incredible team of election lawyers who he works with, and that whole team is really doing some of the most important work for our democracy. So big thanks to Mark and the whole team out there. I'm Ben Meiselas from the MeidasTouch Network. Hit the subscribe button now. We're on our way to 1 million subscribers with your support. Thank you for that. It's free to subscribe, so please subscribe. Also, if you want to support independent media like this, what you got to do is go to patreon.com/MeidasTouch, patreon.com/MeidasTouch. There's a number of different memberships you can join there. If you can join one, we'd appreciate it. There's lots of exclusive content there. Extra podcasts, extra Q&As, extra merch, behind the scenes stuff, some really cool stuff there. But most importantly, help this platform grow. And one of the ways you can do that is by going to patreon.com/MeidasTouch and supporting our work there. We would so appreciate it. I'm Ben Meiselas from the MeidasTouch Network. Until next time.
MeidasTouch is unapologetically pro-democracy. And look, we know you are too. So please make sure you check out our best-selling shirt and our best-selling gear, the unapologetically pro-democracy gear. And hey, while you're at it, make sure you check out my favorite shirt and one of our most famous designs, It Wasn't Rigged, You're Just a Loser, at store.MeidasTouch.com. That's store.MeidasTouch.com.